Good evening, class. Tonight we will begin with the Revised Corporation Code of the Philippines or Republic Act 11232 enacted February 23, 2019. We will begin with Title 1 of the said law, which will discuss the general provisions, definitions, and classifications. So before that, a brief historical background. So the first law to govern corporations in the Philippines is the Corporation Law or Act Number 1459, effective April 1, 1906. And after that, yung Corporation Code of the Philippines or Batas Pambansa bilang 68, which took effect on May 1, 1980. Remember, the Corporation Code of the Philippines reproduced substantially yung old corporation law with amendments. Pero, noong February 23, 2019, the framers of the law enacted the Revised Corporation Code of the Philippines. So, almost all provisions of the Corporation Code were reproduced in the said law, but also there is an introduction of substantial amendments. So, the amendments would cover yung ease of doing business in the Philippines. It also considered advancements made in technology, also made governance of corporations easier while ensuring integrity by imposing stricter good governance standards. It also redefined the powers of the Securities and Exchange Commission and prescribed penalties for violations of the code. And this is very important. It paved the way for the creation of one-person corporations. So nakiuso na tayo sa ibang bansa in such a way that we already entertain yung mga one-person corporations. Now, also, please take note of the definition of a corporation. The definition given in your book is not actually the statutory definition. The statutory definition is found in Section 2. Anyway, yung definition na binigay sa book ninyo, body or artificial person consisting of one or more individuals, sometimes of individuals and other corporations created by law and invested by law with certain legal capacities, such as the capacity of succession, to sue and be sued, to make contracts, to take hold, convey property, and to do other acts, however numerous the membership may be, just like a single individual. So remember, ang mga corporations, marami silang powers, and also the statutory definition of corporations will refer only to private corporations or the corporations organized under the Revised Corporation Code. So obviously, it will not apply to special corporations. So anyway, let's take a look at the statutory definition of a corporation. Ano ang definition ng isang corporation according to law? Found in Section 2. Sabi niya, a corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. Now, if you will take a look at the definition and also take a look at the attributes, yung mga attributes ng isang corporation is the same as its definition. So, pagka definition, pinagsama mo lang yung apat na attributes. Pagka attributes, pinaghiwa-hiwalay mo lang yung mga points ng definition. So, remember again, it is an artificial being. It is created by operation of law. It has the right of succession, and it has only PAP, powers, attributes, and properties expressly authorized by law or incident to its existence. So remember, we will discuss one by one the attributes of corporations. So the first attribute is that it is an artificial being, meaning it is not a real person, but the law will treat it as though it is a person. Now, because a corporation is an artificial being, meron siyang personality, although it is artificial. But anyway, may personality pa rin siya. Now, remember the doctrine of corporate entity. Anong ibig sabihin yan? The personality of the corporation is separate and distinct from its individual stockholders or members and from other corporations to which it may be connected. So, ang tandaan nyo sa doctrine of corporate entity, it talks about the separate personality of a corporation. So, ibig sabihin, yung personality ng corporation, iba yan sa personality ng mga stockholders, iba sa personality ng mga members, and also iba sa personality ng mga corporations to which it may be connected. Ibang tao siya. So, this is not a new concept. We also learned this in partnership. The partnership is a different personality from that of the partners. Same is true here, except na meron siyang pangalan. It is called the doctrine of corporate entity. Now also remember the effects of juridical personality of a corporation. Number 1, a corporation will be liable only for corporate debts. So, yung mga stockholders tsaka members, if they have personal debts, obviously the corporation will not be liable because ang personality ng corporation is separate and distinct from the stockholders. What else? In relation to this, please take note of the principle of limited liability. So this will refer to the protection from liability of shareholders or members. Yung protection nila is from payment of corporate debt or credit. So remember, yung corporate debt is not the debt of a stockholder or a member. Also, in the same light, a credit is a stockholder or a member is not entitled to the credit which is due to a corporation because of the separate personality. So remember the principle of limited liability. Also number 2, because of the juridical personality of a corporation has right to bring actions. So ang corporation pwedeng magdemanda yan, pwede rin siyang idemanda. So it may bring civil actions, criminal actions, as if it is a real person. Pwede rin naman siyang mademanda as if it is a real person. What else? Number 3, a corporation also has the right to acquire and possess property. And if a corporation has properties, it will be registered obviously in the name of the corporation. So the property of the corporation is the property only of the corporation. It is not the property of the stockholders or the members. How about number 4? There are liability for acts or contracts. So remember, due to the separate personality of a corporation, obligations which are incurred by a corporation, even if it is incurred by the stockholders or the board of directors, by the directors or agents acting, agents. Remember class, the rule is that the corporation will be made liable for contracts entered into in its representation. What else? Personal obligations of stockholders or members are not liabilities of corporations. Yan. What else? Tax exceptions are personal to corporations. Changes in individual membership will not affect the corporation. Kasi nga, remember, ang corporation is not dissolved due to the change in membership. What else? Please take note also of, in addition to the doctrine of corporate entity, take note also of the doctrine of piercing the veil of corporate fiction or disregarding the fiction of corporate entity, or doctrine of corporate alter ego. These are the same animals. Doctrine of piercing the veil of corporate fiction, doctrine of disregarding the fiction of corporate entity, or doctrine of corporate alter ego. These are the same animals. So this is, remember, dahil nga merong limited liability ang mga stockholders or members, meron silang protection. So corporate debts, hindi sila liable dyan. Kung baga, corporate debts should be the liability of the corporation. However, there are times that the law will impose personal liability against the stockholders or the members. So, yung fiction na to, pagka kasi nasa corporation, kaya marami nag-incorporate class eh. Kasi mayroong protection. Kumbaga, pagka, remember in partnership, ang general partner is liable up to their personal properties. In a corporation, ang stockholder, pagka nag-invest siya, yun na yun. So, pagka mayroong corporate debts, naubos na ang corporate assets, wala ka nang makukuha sa mga individual stockholders or members. So, there is actually a veil of protection for the stockholders or members. Protected sila. Pagka ubos na assets ng corporation, hindi na sila liable. But there are times when the veil of corporate fiction is pierced or binubutas yung protection. Or the fiction of corporate entity is disregarded. So the rule is the fiction of corporate entity is disregarded or the veil of corporate fiction or yung protection ng mga stockholders or member is pierced when the fiction of corporate entity is used for fraud to defeat public convenience, protect fraud, defend crime, serve as a mere alter ego or business conduit of a person or another corporation. So, sa madaling sabi, if yung corporate personality or corporate entity is used for fraudulent purposes, then pwedeng i-pierce yung veil ng corporate fiction or pwedeng i-disregard yung protection which is given to the stockholders or members. In fact, sabi niya, the law will not recognize a separate corporate existence and the stockholders or members will be considered as the corporation and liability will attach personally or directly to the officers and stockholders. So remember that. Also, there are several instances when the fiction will be disregarded. Please take note of this. They are all in your book. Number 1, where a corporation functions for the benefit of a single individual. So, if a person has complete control over the funds and one person is the sole owner of the entire corporation, remember class na pwedeng i-pierce yung corporate fiction or yung corporate entity if this corporation which functions for the benefit of a single individual is used to protect fraud. What else? Number 2, when a corporation is a mere instrumentality of individual stockholders. Again, if there is fraud, pwedeng i-disregard yung corporate entity. Also, please take note of the instrumentality rule or alter ego rule, where it appears that the corporation functions for the benefit of another corporation. So may corporation pero meron siyang ibang corporation and this corporation will function for the benefit. Usually nangyari ito sa parent and subsidiary corporation. But remember also that if there is no fraud, there is no reason to pierce the corporate veil. What else? Domestic corporation is controlled by aliens. So remember class, it depends on the control test. Yan. So, for during wartime, for reasons of national security, titignan kung ano ang nationality ng isang corporation. So, if it is controlled by aliens, remember class that the fiction of corporate entity will be disregarded. What else? Where a corporation is organized by an insolvent debtor, yung insolvent debtor will transfer all his properties to the corporation, and obviously, yung mga kanyang personal creditors cannot collect from him. So, obviously, yung corporate entity is used for fraud. Pwedeng magkaroon ng piercing ng corporate veil. Subsidiary company is created by a parent company. Not automatically, but if there is a fraud, remember that the fiction of corporate entity may be pierced. What else? Corporation is formed by a person for the purpose of evading his contract. Again, this is fraud. Iniiwasan niya yung contract niya. So, obviously, may fraudulent purposes. That's why the doctrine of corporate entity will be disregarded. What else? Number 8, dissolved corporation and its assets are transferred to another corporation to avoid financial liability of the first corporation. So, obviously, fraudulent ito. Lilipat mo lahat ng assets mo sa bagong corporation para lang yung creditors ng original corporation mo hindi mo na kailangang bayaran. What else? So, yun ang mga examples ng mga instances when the corporate fiction will be disregarded. What else? Please take note also that a corporation is a creation of law or it is created by operation of law. Anong ibig sabihin yan? Corporations are not created by agreement. Yan. But a corporation will require a special authority or grant from the state or the government. So, para itong limited partnership, remember your limited partnership is a creation of law. Ang private corporations also, it is a creation of law. So, it cannot come into existence by mere agreement. So, remember yung special authority or grant from the state is exercised by a special incorporation law or charter. So, yung special incorporation law or charter which will allow us to create corporations or yung general incorporation law, ang general incorporation law natin is yung Revised Corporation Code of the Philippines. So, dahil sa law na yon, we can create private corporations. But remember, compliance with the procedure and conditions provided under the law for incorporation must be complied with. So, yun ang kailangan yung tandaan. What else? Number 4, it has the right of succession. So, remember, a corporation can exist perpetually. So, regardless of the death, withdrawal, insolvency, or incapacity of the individual stockholders or members, even if their interests in the shares of stocks are transferred to other individuals. Unlike in partnership, may namatay lang, dissolve. Meron lang nag-resign, dissolve, withdraw, etc. Pwedeng ma-dissolve yung partnership. But here, remember, capacity of continuous existence. What else? Also, it has only the powers, attributes, and properties expressly authorized by law or incident to its existence. So, remember class, yung mga powers which can be exercised by a corporation are yung express, which are obviously granted by the General Incorporation Law and also the Articles of Incorporation. So, also, please take note that pwede rin mag-exercise ang corporation ng implied. So, implied powers are those which are gathered from the express powers, and also yung mga incidental powers which are essential to the corporation's existence. So, any power outside yung mga sinabi ko, express, implied, or incidental, remember class, they are any act exercised outside of the powers are considered ultra vires acts. What else? Take note of Section 3. The classes of corporations under the Revised Corporation Code. Marami yan, but I will discuss only 3. Kayo nang bahalang magbasa nung iba. Number 1, yung stock corporations. So remember, ordinary business corporation created for profit, and meron siyang capital stock and distributed it has capital stock divided into shares. And remember, they are also authorized to distribute yung kanilang profits in the form of dividends to stockholders on the basis of the capital invested. So, yun ang kailangan natin tandaan sa stock corporation. Yun namang non-stock corporations, they do not issue shares of stock, they are not created for profit, but for public good and welfare. So, usually, ang mga non-stock corporations, yung mga religious, charitable, social, literary, scientific, civic, and political organizations and societies. So, ang kailangan yung tandaan sa non-stock corporation, it may make profit, but the profits are not distributed to the members. May pera din ang non-stock corporation kasi nagko-contribute ang mga members. At the onset, there are contributions from the members. What else? Also take note of yung bago, yung one-person corporation or yung OPC. So, this is a corporation formed by a single stockholder. Ang single stockholder na yan is maybe a natural person, a trust, or an estate. So, yun lang tatlo ang pwedeng mag-form ng one-person corporation. So, anyway, there are several other classifications of corporations. Please read them, take note of them. We will discuss them on Saturday. What else? Please take note of Section 4. Corporations created by special laws or charter or special corporations. So, obviously, class, into mga special corporations na to, are not the corporations covered by the Revised Corporation Code kasi mga private corporations lang ang pinag-usapan natin sa RCCP. So remember yung special corporations, pwedeng mag-create ng mga ganyan. But remember class that pagka nagkaroon ng special corporation, merong constitutional limitation that it shall be owned or controlled by the government or any subdivision or instrumentality thereof. So, a special act creating a private corporation, remember, kailangan controlled or owned by the government. Yan. What else also? The governing laws for special corporations, primarily by yung special law or charter which created them or which is applicable to them, and suppletorily by the provisions of the Revised Corporation Code insofar as they are applicable or they are not inconsistent with or expressly made applicable by the special laws. So, tandaan nyo ang mga corporations by, private corporations by special act or charter or special corporations are not created under the Revised Corporation Code but they have their own law. So, yun ang kailangan yung tandaan. How about the components of a corporation as found in Section 5? So, the persons who compose a corporation are number 1, the corporators. So, corporators comprise of stockholders or members and also include yung incorporators. So, any person who is a part of a corporation is called a corporator. How about yung incorporators? So, incorporators are stockholders or members who originally formed and composed yung corporation. So, they are the signatories to the Articles of Incorporation. So, obviously, all incorporators are corporators, but not all corporators are incorporators. So, what else? Stockholders or shareholders. Remember, these are the owners of shares of stock in a corporation, in a stock corporation. So, they may be natural or juridical persons. What else? Members naman, corporators of a non-stock corporation. So, what else? 3 other classes. Promoters. So, promoters are persons alone or with others undertakes to organize a corporation. So, they will procure the necessary legislation, find subscribers, find incorporators to the Articles of Incorporation. So, if the corporation is organized under general laws, they will draft the document. They will see to it that the necessary document is presented to the SEC for recording, and a certificate of incorporation is issued. So, generally, your promoters will promote the company. So, yun ang kailangan yung tandaan. So, maghanap sila ng subscribers, maghanap sila ng incorporators, magbebenta sila ng mga shares even before the corporation is established. What else? Subscribers. So, persons who have agreed to take and pay for original unissued shares of a corporation formed or to be formed. So, sila yung bumibili ng mga shares of stocks. So, subscribers, remember, may not be stockholders. They will become stockholders from the time that their subscriptions are accepted by the corporation. What else? Yun namang underwriter. Usually, an investment banker. Remember, they will exert yung best efforts to market all or part of an issue which he has offered for sale or has purchased from a controlling stockholder. So, remember, these are the persons who comprise yung corporation. How about Section 6, classifications of shares? So, remember, the power to classify shares is granted to the corporation. So, shares of stock may be divided into classes or series of shares or both, any of which classes or series of share may have such rights, privileges, or restrictions as may be stated in the Articles of Incorporation. So, remember, class na sa ang corporation, pwede siyang mag-issue ng isang klase lang ng share, pwede siyang mag-issue ng maraming klase ng share. But remember, again, that a corporation must have one class with complete voting rights. Yan. What else? classification of shares may be made, remember, by the incorporators. So, pwede sila mag-classify. Ang mga incorporators ang nagsasabi na ano bang klaseng share ang i-issue natin. Common ba or preferred? Magkano ang par value kung ito ay common share? Kailangan ba natin mag-issue ng no par value, etc. etc. So, it is the incorporator who will determine the class and the number of shares which shall be issued by a corporation. Because remember, ang corporation has the power to classify its shares depending on the needs of the business. So if a corporation has the power to classify shares, the question now is, sino ang magka-classify ng shares at saka kailan? So classification of shares may be made by the incorporator. So obviously, kailan? At the onset of the corporation, nung time na ini-incorporate pa lang siya. Because remember, the incorporators will determine the authorized capital stock. Kung anong authorized capital stock ng isang corporation by which it can transact its business. So remember, ang incorporators, siya ang magdedetermine ng authorized capital stock, kung anong class ng share ang i-issue, preferred ba, common ba, voting, non-voting, etc. etc. Tapos also the number of shares to be issued. It is the incorporators who will determine. So they will state that in the articles of incorporation, and the same will be filed with the SEC. Now, later on, if yung mga board of directors and the stockholder wish to amend the classification of shares, gusto nila magdagdag, etc., they can so amend yung articles of incorporation. So they will alter yung classifications of share by amending the articles of incorporation. So amend the articles of incorporation by majority vote of the BOD and vote or written assent of the stockholders representing at least 2/3 of the outstanding capital stock. So yung 2/3 OCS, it is dependent on the number of shares voting for an amendment of the articles of incorporation. It does not depend on the number of stockholders. It is financial interest class actually. So, pagka nagkaroon na ng amendments sa articles of incorporation, bababago na yung classification at saka yung number ng shares. Now, if any stockholder does not agree doon sa classification of shares, any stockholder may exercise his appraisal right. So, what is the appraisal right? The appraisal right is the right of a stockholder to be paid the fair value of his share. So, in short, the stockholder, iba-buy out siya ng corporation. So, yung shares held by the stockholder, iba-buy out ng corporation yan. Kasi the stockholder is no longer interested in remaining with the corporation. So, i-exercise niya yung kanyang appraisal right. Iba-buy out siya ng corporation. So, anyway, the exercise of the appraisal right is valid under certain circumstances, subject to certain requirements and limitations. We will later on find out when we go to Title 9. So, yun ang kailangan nating tandaan sa classifications of shares. Now, also take note that shares are also presumed to be equal in all respects. So, ito ang tawag dito ay doctrine of equality of shares. So, in the absence of any provision in the articles of incorporation, all stocks, regardless of name, enjoy equal rights and privileges subject to the same liabilities. So, yun ang presumption. But obviously, there can be differences in the rights and privileges of shares of stock. So, depending din sa klase ng shares. And obviously, okay lang naman na may difference between the rights and privileges of a common share and the rights and privileges of a preferred share. Obvious yun, it is expected na mayroong pagkakaiba. But remember, class, absent any provision in the articles and the certificate of stock, there is a presumption that all shares are equal. What else? In your book, please take note of the term capital stock and the kinds of capital stock. Be able to differentiate them and identify them. So, iwan ko na sa inyo yon, or else this will be a 3-hour video. So, pahala na kayo doon. Please take note of the classes of shares in general. We have par value share. Ano ba yung par value share? It has a specific money value. So, yun ang babayaran ng isang tao para sa share na yon ng capital stock. So, the par value is usually fixed in the articles of incorporation and it will appear also in the certificate of stock. Usually, yung par value is yung minimum issued price ng shares. So, yun ang minimum amount that the stockholders will receive for the stock. But, remember class, it is usually not the price at which investors or stockholder will buy or sell the shares. So, yun ang tandaan nyo sa par value shares. What else? No par value shares naman. It does not have any stated par value appearing on the face of the certificate of stock. So, hindi alam kung magkano ang value na nire-represent ng isang no par value share. Although, a no par value share always has an issued value. So, yung issued value is the amount that you will pay for the issuance of a no par value share. Usually, the minimum consideration for no par value share is 5 pesos. Yan. So, what else? We will discuss later on more about no par value shares. Voting shares naman, they have a right to vote. Usually given ang right to vote to the common stock and withheld from the preferred stock. So, pagka sinabing voting to approve a particular corporate act, ang tinutukoy lang yan is stock with voting rights. However, there are instances when non-voting shares are allowed to vote. So, anyway, we will talk about yung non-voting shares. So, shares without right to vote. Usually, class, ang mga dinedeprive ng voting rights ay yung mga shares which are issued as preferred or redeemable shares. But if there are non-voting shares, it is required by law that merong isang class ng share na i-issue ang corporation with complete voting rights. Also, remember, non-voting shares can vote in some instances provided by law, which we will discuss later on. What else? Common share of stock. So, entitles the holder to a prorated division of profits if there are any. Yung mga holders of a common shares, they are called residual owners. So, kung merong assets left over after liquidation, after all the debts are paid, and after all the yung mga interest ng mga preferred shares ay nabigay, kung may natira, they will receive yung kanilang share, tapos prorata pa. What else? Preferred share of stock naman. The holder will have certain preferences over the holders of common stock. So, yung preference may consist in the payment of dividends or the distribution of assets upon dissolution. So, or other preferences, basta nakalagay sa articles of incorporation. So, yun ang kailangan yung tandaan sa preferred shares. Pagka preferred shares, it is always issued with par value. So, pagka preferred, always with par value, walang no par value preferred shares. So, yun ang kailangan nating tandaan. What else? Please take note also of your promotional stock or promotion stock. These are issued to promoters or people who are in some way interested in the company, or yun nga, issued for incorporating the company or for services in launching or promoting yung corporation. What else? Shares in escrow. Remember, ang shares in escrow is merong isang grantor who would want to give to a third person or beneficiary yung shares of stock. But in the meantime, it is placed in the name of an agent. So, yung agent na yun will keep the share of stock until the fulfillment of a certain condition. Tapos, at which time, remember class, doon pa lang i-release yung share of stock doon sa beneficiary. So, kailangan yung tandaan dyan, the person who is entitled to receive the share of stock will not receive it until the condition is fulfilled. What else? Convertible stock. Yung convertible stock naman is changeable from one class to another class. So, preferred to common, etc. at the conversion ratio. So, yung price of the common valued as against the preferred if that is the conversion. So, usually it is the stockholder who will demand conversion at his pleasure unless otherwise provided for in the articles of incorporation. What else? Fractional share, less than 1 share. Over-issued share naman, stock issued in excess of the authorized capital stock. So if your authorized capital stock is 1 million pesos, divided into 1,000 shares, nakapag-issue na kayo ng 1,000 shares of stock, yung anything in excess of 1,000 shares of stock are over-issued stock. Remember, over-issued stock are issued as null and void as a general rule. Please take note also in your book of yung differences between par value, book value, and market value. So anyway, statutory restrictions, sabi ko sa inyo, pag-usapan pa natin lalo yung no par value shares. So these are the restrictions regarding no par value shares. Number 1, banks, trust companies, insurance companies, pre-need companies, public utilities, buildings and loan associations, and other corporations which will obtain or access funds from the public cannot issue no par value shares of stock. So, corporations vested with public interest cannot issue no par value shares of stocks. What else? Preferred shares issued only with par value. So, preferred par value. So, hindi pwedeng yung no par value preferred share. What else? Shares issued without par value shall be deemed fully paid and non-assessable. And the holder of such shares shall not be liable to the corporation or to the creditors in respect thereto. So, ang kailangan nyo tandaan, pagka nag-issue ng no par value shares, mag-i-issue lang ng certificate of stock if it is fully paid. So, hindi pwedeng installment payment ang mga no par value shares. They are always deemed fully paid and non-assessable. What else? Please take note also of number 4, shares without par value may not be issued for less than 5 pesos per share. So remember, wala nga siyang par value, pero meron siyang issued value. And the issued value should not be less than 5 pesos per share. What else? Entire consideration received by the corporation for no par value shares shall be treated as capital and shall not be distributed as dividends. So, kailangan yung tandaan sa mga no par value shares, kung ang issued value niya is 5 pesos, remember class, even if the corporation receives more than 5 pesos or more than the issued value, hindi ito treated as capital and it cannot be available as dividends for distribution to stockholders. So ito yung tinatawag yata nila na share premium. So even if it is sold at a higher price, ano pa rin yan, part ng capital, hindi pwedeng i-distribute as dividends to stockholders. What else? Articles must state the fact that it issued no par value shares. So, kailangan lang nakalagay sa articles na ang kanyang in-issue ay no par value shares, and remember also, kailangan ilalagay doon yung number of shares. What else? Right to vote of voting shares. So, kailangan nating tandaan in stock corporations, ang mga shares of stock is entitled to vote. Yan. So, unless it is delinquent or unless otherwise provided in the articles of incorporation. What else? Unissued stocks may not be voted kasi wala namang may-ari dyan, and it is not counted in determining whether there is a quorum or not. What else? Shares also reacquired by the corporation and remaining in the treasury have no right to vote. What else? In non-stock corporations, membership, 1 vote per member. Yan. Unless it is limited, broadened, or denied in the articles of incorporation or the bylaws. Please take note also of the kinds of preferred shares. So, preference as to assets, preferred as to dividends, yung cumulative preferred, non-cumulative preferred, participating preferred, non-participating preferred, cumulative participating preferred shares, be able to identify them and to differentiate them with one another. What else? Preferred shares, these are the limitations regarding the issuance of preferred shares. So, a corporation may issue more than one class of preferred stock. So, pwedeng preferred A, preferred B. Yung preferred A ay, ang preference niya is as to assets. Preferred B, ang preference niya is as to dividends. Yan. So, tandaan nyo, unless there is a different classification provided in the articles, the rule is that preferred shares enjoy the same preferences or privileges, unless otherwise provided. What else? Number 2, preferred shares deprived of voting rights shall still be entitled to vote in the matters enumerated in Section 6, which we will discuss later on. What else? Number 3, preferences of preferred shares must not violate the provisions of the revised corporation code. What else? Preferred shares may be issued only with a stated par value. Ilang beses ko nang inulit to. If it is a preferred shares, hindi ka pwedeng mag-issue ng no par. What else? Board may fix the terms and conditions of preferred shares of stock or any series thereof when authorized by the Articles of Incorporation. Yan. So, if magkakaroon ng terms and conditions regarding preferred shares, at this will be determined by the board, the board must be authorized by the articles to fix the terms and conditions of preferred shares. Also, lastly, instances when non-voting shares are allowed to vote. Sinabi ko na to kanina, acid drip. So, in the amendment and adoption of the Articles of Incorporation or the bylaws. So, in amendment also, remember, non-voting shares are allowed to vote. Disposition of property, anong ibig sabihin yan? Any proposed action to SLEMPO, sell, lease, exchange, mortgage, pledge, or other act that would dispose all of or substantially all of the corporate property. So, even non-voting shares are allowed to vote if that is the issue at hand. What else? Indebtedness, any proposed act to incur, create, or increase funded indebtedness. We will discuss more about funded indebtedness when we go to Title 4, Powers of a Corporation. What else? Number 5, capital stock. So, any proposal to increase or decrease the capital stock, pwedeng bumoto dyan yung mga holders of non-voting shares. In case of corporate restructuring, meaning merger or consolidation with another corporation, needs the approval of even non-voting shares. What else? Investment of corporate funds in another corporation or business, self-explanatory yan, and also dissolution. Any planned termination of corporate life, pwedeng bumoto yung mga holders of non-voting shares. What else? In addition to that, Section 7 talks about your founders' shares. So, yung founders' shares issued to organizers or promoters of a corporation. So, nag-share naman sila sa profit, but they have certain rights or privileges over other stocks, such as the exclusive right to vote and be voted for in an election for directors. Such right is only for a limited period not exceeding 5 years. So, yung 5-year period will start from the date of incorporation. What else? As to division of profits, meron din silang privilege doon. So, what else? Bakit daw binibigay? Kasi sila yung nag-umpisa ng corporation. What else? Classification of shares. Also, please take note of redeemable or callable shares under Section 8. So, please take note of the term redemption. Redemption is the repurchase, reacquisition of a stock by a corporation, which issued the stock in exchange for cash or property, whether or not the acquired stock is cancelled, retired, or held in the treasury. So, basta a corporation buys back shares of stock, it is called redemption. Yan. So, remember, redeemable or callable shares are usually preferred shares. They are redeemable at a fixed date or at the option of either the corporation or the stockholder, or both at a certain redemption price. Yan. So, the limitations on redeemable shares, ito yung nasa kamay na ng stockholder, binili uli ng corporation. So, binayback ng corporation itong mga shares na to. So, in case of issuance of redeemable shares, it is issued only when expressly provided in the articles of incorporation. Yan. What else? Number 2, terms and conditions. So, yung terms and conditions which will affect the redeemable shares, not only in the articles but also indicated in the certificate of stock. What else? Voting rights. Redeemable shares may be deprived of voting rights unless otherwise provided for in Section 6, meaning yung acid drip. So the next one is that redemption can be made regardless of existence of unrestricted retained earnings but cannot be made if it will cause insolvency. So please take note of the term unrestricted retained earnings because we will encounter it several times throughout our discussion. Mas ang unrestricted retained earnings is yung earnings ng corporation na hindi earmarked or for a definite corporate purpose or hindi siya nakalaan para sa isang corporate purpose. That's why it is called unrestricted retained earnings. Now, remember, ang ating mga redeemable shares, pwede yang i-redeem even if there are no unrestricted retained earnings. But it cannot be made if it will cause insolvency to the corporation. So, even if, ayan nga sabi, no unrestricted retained earnings on the books, pwedeng i-allow yung redemption ng shares because the redemption is provided for by contract between stockholder and a corporation. However, ito nga, the corporation must have sufficient assets to cover debts and liability inclusive of capital stock. Yan. So if yung pagre-redeem ng mga redeemable shares, it will cause insolvency to the corporation, hindi muna dapat i-redeem yung mga redeemable shares even if it is already redeemable at that time. Yun ang tandaan natin sa redeemable shares. What else? Treasury shares, Section 9. So, Section 9 covers yung treasury shares which are lawfully issued by the corporation. And remember, these are already fully paid shares. But later on, they are reacquired by the corporation for one reason or another, either by purchase, redemption, donation, forfeiture, or other lawful means. So, yung mga treasury shares, obviously, nasa treasury yan. Now, the rules regarding treasury shares, number 1, a corporation may purchase or acquire its own shares for legitimate corporate purposes. So, usually, in delinquency sales, yung mga shares na par value shares ito na may mga balance tapos yung balance hindi nabayaran, so they will become delinquent shares and then they will be sold in delinquency sales or yung mga auction ng mga shares of stock. So usually pagka walang bidder na bibili dun sa mga delinquent shares, the corporation can reacquire yung kanyang own shares, in which case magiging treasury shares siya. Yan. What else? Also, take note that treasury shares are not retired shares. They will not become unissued shares. Hindi sila babalik as unissued because, remember, ang treasury shares na issue na yan, nabayaran na nga talaga, fully paid, except that they are reacquired by the corporation at some future time. Yan. But, what you have to remember about treasury shares also is that they can be reissued or resold by the corporation at a fixed price or price fixed by the board of directors. Yan. Pwede naman ding lower price, pero it should be reasonable price. Yun ang sabi ng law. And also, treasury shares are issued shares kasi nga, remember, issued, fully paid, etc. But reacquired later on. But because they are in the treasury, they do not have the status of outstanding shares. So remember, yung outstanding share is any shares that are not in the hands of the corporation. So dahil nasa treasury siya ng corporation, obviously they are not under outstanding shares. So not part also of the capital stock. Yan. What else? You can resell yun ngang treasury shares at a price the board of directors sees fit, even at less than par value, provided that the price is reasonable under the circumstances. Pagka naibenta na, it will become, pag may bumili na, it will become outstanding stock and magkakaroon siya ng dividend and voting rights. Yan. Declaration as property dividend. So, treasury shares, dahil ito ay unrealized income and not considered as part of earned or surplus profit, hindi siya distributable as dividends. Or, remember, not distributable as cash dividend or stock dividend, but remember, they can be distributed as property dividend. Yan. Tandaan natin sa treasury shares. What else? Voting rights. Obviously, they have no voting rights dahil siya ay hindi naman outstanding and it is in the treasury. Yan. So, and anyway, remember yung mga redeemable shares nyo. Pagka ni-redeem na yon, if it is not cancelled after redemption, it will become treasury shares. Yun ang tandaan natin. Dividends, also, your treasury shares are not entitled to dividends. So, anyway, kasi sino ang may-ari ng treasury shares? Yung corporation. Alangan namang mag-declare ang corporation ng dividends for itself. So, bawal yun. What else? I think that's it for Title 1 of the Revised Corporation Code. Please stand by for Title 2. Thank you, class.